Welcome to the Deep Dive. This is the show where we take a whole stack of dense sources. We're talking police citations, court documents, state laws, and we try to pull out the crucial insights and the context you really need to understand a complex story.
And our mission today is, well, it's a difficult one, but it's incredibly important. We're going to be looking at a recent and very disturbing criminal case out of Kentucky. It involves a fifth-grade teacher and a student.
But the real deep dive here is into the law itself.
Exactly. The immense legal muscle of the electronic exploitation statutes that were used to bring the charges. We're going to show you exactly why, in this digital age, criminal intent can matter so much more than actual physical contact.
Okay, let's unpack this and set the scene. The case is centered on Sydney Graff, a 36-year-old fifth-grade math teacher. This is at Smyrna Elementary School in Louisville, Kentucky.
And the alleged offense, it's tough to talk about, but the legal structure around it is something everyone should understand. It all allegedly happened on December 15th, 2025.
And that date is important, right?
It's a crucial piece of the context. It was a non-traditional instruction day, an NTI day, remote learning. So the entire alleged interaction, the entire offense, it was all conducted electronically.
So Graff was charged under Kentucky state law.
Yeah.
Specifically, it's KRS 510.155.
Right. That's the statute that covers procuring or promoting the use of a minor by electronic means.
And it's not a simple charge.
No, not at all. So initially that charge is a Class C felony, but the law has these really serious escalators built in. And here's the key point for you, the listener. Because the victim was under 12 years old and Graff was in a position of authority, I mean, she was his teacher, the charge elevates a lot.
It becomes a Class B felony.
It becomes a Class B felony, which carries much, much steeper penalties. That dual condition, the victim's age and the suspect's authority, it just makes the whole thing exceptionally severe from the get-go.
The details from the police citation are, they're explicit and really unsettling, especially when you think about the age of the student.
So Louisville Metro Police detectives get involved after the Jefferson County Public Schools Police, their own police force, contacts them about what they called exploitation of a juvenile victim.
And the core of it is the allegation that Graff was having these sexual conversations with this fifth-grade student, a boy under the age of 12.
And the conversations, based on the evidence, they moved into very explicit territory very quickly.
Yeah, the police citation included a specific quote that was just deeply disturbing, allegedly from Graff. It said, "I really need to taste that, Davy FR."
And it's that mixture of content and language that's so unsettling. The use of slang like FR, for real, it's something we often see in these cases.
It's a way to connect.
It's a calculated attempt to break down that authority barrier, to talk to the child using their own language and, well, accelerate the grooming process.
And what's sobering here is how solid the evidence seems to be. This wasn't just one person's story.
No, the detectives reviewed screenshots, and this is critical, video recordings of these conversations.
Yeah.
And the documents we have confirm these digital records clearly showed Sydney Graff's name and her image.
So it directly links the communication to her.
Absolutely. That digital trail is paramount. The technology is what enables the crime, but it also creates this really irrefutable evidence for the police.
And it didn't just stop with the messages. The citation alleges she actually made arrangements to meet the boy in person.
On that very same day, December 15th, that NTI day. And that's really where the law enforcement response had to become critical and fast.
Since they moved in.
They moved very quickly. She was apprehended by police while she was allegedly trying to pick up the child right in the area of his home. The investigation had clearly gotten to the point of active intervention.
And then after the arrest, the citation says that after being read her Miranda rights, Graff admitted to the conversations.
She did, allegedly. But it's really important to note that tension in the courtroom later on. When the prosecutor brought up the attempt to pick up the child, Graff was apparently seen mouthing the word no.
Oh, wow.
So you see the defense strategy forming right there in that moment, challenging that specific physical, escalating part of the charge, even when the digital evidence seems so overwhelming.
The stakes were obviously incredibly high right away. Her bond was set at $100,000 cash.
With no partial or property bonds allowed. That's a huge indicator of how seriously the judge was taking this.
And the conditions, if she did post bond, were just incredibly strict.
Yeah, she was ordered to the home incarceration program, HIPPSO, house arrest, basically.
Right.
No social media, no contact with the victim or any other minors, no contact with any school property. And she did eventually post that bond.
And of course, there was the school's response.
Right. The principal at Smyrna Elementary, Amanda Cooper, sent a letter to parents. It confirmed Graf would be reassigned and would have no contact with students while the investigation was ongoing.
And the case itself is moving forward. It's been waived to a grand jury.
Right.
So we have all these details, but what's so astounding, legally speaking, is that the law didn't even need that attempted meeting to make this charge stick. Let's get into why. Why is this statute, KRS 510.155, set up this way?
That is the key legal insight here. This statute doesn't wait for physical harm to happen. It targets the purpose of using the electronic communication, a computer, a phone, anything.
So it's about the why.
It's all about the why. The purpose has to be procuring or promoting the use of a minor for sexual activities. The crime is literally finished the moment that specific intent is typed out and sent.
Okay, to really get that, we have to break down those two legal terms, procuring and promoting. What do they actually mean here?
So if we look at a source like Black's Law Dictionary, procure means to obtain a sexual partner for another, especially an unlawful partner like a minor in, plain English. It means actively setting up the connection.
Arranging the opportunity.
Okay.
And promote.
Promote is even broader. It's defined as preparing, publishing, or, and this is the most critical part here, to offer or agree to do those things.
So the offer itself is the crime.
The offer itself is enough to satisfy that element of the crime.
So if you send a message with that intent to arrange or prepare for a sexual act with a minor, that's it. The crime is done. You don't have to follow through.
Precisely. And the Kentucky legislature spelled this out so clearly. The statute itself says that the solicitation of a minor through electronic communication shall be prima facie evidence of the person's intent. And the offense is complete at that point.
With regard to whether the person met or attempted to meet the minor.
Wow. That nuance is what makes this law so powerful in, preempting physical harm. Graf's alleged attempt to meet the student, that made the case far more serious for bail, for potential sentencing, but the charge itself was already complete the moment she hit send.
It just completely shifts the legal focus away from physical location and onto the digital act and the intention behind it.
It does, and this leads us perfectly into the legal precedent that shows just how incredibly expansive this law is. And that's the 2019 case, Caton v. Commonwealth.
Right, the Caton case. And this one tackles a really interesting question. Do you have to be talking directly to the minor for this law to apply?
It seems like you should, doesn't it? I mean, if you're procuring a minor, you'd assume you have to talk to the minor. But James Leroy Caton was convicted after communicating with someone he believed was an adult, an intermediary.
Okay, walk us through how that worked.
So Caton was talking to an undercover agent. This agent, who used the name Vanessa, was posing as an adult mother. And she offered to arrange a sexual encounter between Caton and her supposed 13-year-old daughter.
So Caton thinks he's talking to an adult, the mom, to set up a meeting with the child later. What was his defense?
Well, his defense was basically a loophole argument. He said the law should only apply if he was talking directly with a minor or maybe a police officer pretending to be a minor.
But since he thought he was talking to Vanessa, an adult facilitator,
he claimed the law just shouldn't apply to him. It was a really bold attempt to find a huge gap in the statute.
And how did the Kentucky Court of Appeals see it?
They completely rejected it. They affirmed the conviction. They held that communicating with an adult intermediary for the purpose of bringing about an illegal sexual encounter with a minor is totally consistent with what the statute is trying to prohibit.
Which is the procuring or promoting.
Exactly. The court was just emphatic. It's the intent that is focused on the minor, and it doesn't matter who is actually on the other end of that electronic message.
That ruling is so powerful. It basically closes the door on any ambiguity in, say, sting operations, where an officer poses as a parent.
Right. It makes it clear that the criminal intent focused on the child is what matters, not the identity of the person holding the phone. The law sees using technology to arrange access to a minor, even through a third party, as the same as direct solicitation.
And the legislature actually reinforced this.
They doubled down on it. The current version of the statute now explicitly criminalizes using electronic means for the purpose of procuring or promoting the use of a minor from an adult intermediary. And it even says, including a peace officer. They sealed that loophole shut for good.
So if we bring that back to the Graf case, the charge is just incredibly strong. I mean, he or she allegedly was talking to the child, but the legal structure would hold up even if she wasn't.
That's the power of it. The intent to procure a minor is the beginning, middle, and end of the crime.
Let's shift a little bit then to the non-legal side of this, the dynamics of the case, because this is where that profile paradox really, really hits home.
It's the classic pattern, isn't it? Graf's public image was that of a super dedicated teacher.
Not some stranger from the internet.
Not at all. She was deeply integrated into that school community. We know she was planning to loop with her 4th grade students up to 5th grade because she felt so invested in them. She was raising money online for flexible seating in her classroom to give them the best learning environment possible.
She's also married with 2 kids of her own. And that position of deep community trust is exactly what gets leveraged in the grooming process.
It is. A former prosecutor who's worked these kinds of cases confirmed that messages like the one Graf allegedly sent, they almost never come out of the blue. They follow a very specific process.
An escalation.
An escalation. It starts with simple boundary-blurring behavior, and it leverages that trust that a child has learned to place in a teacher.
So the teacher is this trusted mentor, and then the lines start to get blurred, maybe through overly familiar texts or messages before it ever gets explicit.
And that remote learning day, that NTI day, it essentially stripped away the public visibility of a classroom and provided this private electronic space for that alleged boundary pushing to happen.
One thing that always causes public confusion is the school's response, the reassignment, not an immediate firing.
And that's not the school protecting the employee. It's a procedural necessity.
So why can't a public school system like JCPS just fire someone immediately when the allegations are this severe?
Due process. It all comes down to due process. You can't just summarily dismiss a public employee, even when they're facing criminal charges. Reassignment, which usually means paid leave or non-contact work at a district office, is the required intermediate step.
It's built into union contracts and school protocols.
Contracts, protocols, and often federal regulations like Title IX, while the internal HR investigation runs its course.
So while the public might see reassignment and think the school isn't acting, it's actually the mandatory first step that ensures if they do fire her, it will stick legally.
Exactly. It protects the integrity of the process. And speaking of process, the police investigation is now probably incredibly wide.
This arrest isn't the end of it. They'll be looking for any evidence of past misconduct.
Oh, absolutely. They will subpoena every electronic record they can get their hands on, personal and school-related, and they'll be canvassing the community. Talking to other students, other parents, essentially running a full background check on her entire time at that school to make sure there aren't any other victims. That process tends to accelerate once a story like this becomes public because other people start to come forward.
So if we zoom out, we started with this one, tragic local case in Kentucky, but we've ended up at this massive legal precedent about electronic interaction that really, it affects everyone.
The Graf case is just a chilling, real-world example of that dual nature of technology. Technology tragically enabled the alleged crime by providing that private channel on a remote learning day. But on the other hand, that same digital trail, the screenshots, the video, the quote, it provided the critical, irrefutable evidence the prosecution needed.
The ultimate takeaway for you listening is really the power of this specific kind of law. The legal landscape in Kentucky, which was so powerfully affirmed by cases like Caton v. Commonwealth, it ensures that the crime is focused entirely on the intent to procure a minor.
Regardless of whether the communication is direct or through someone you think is an adult intermediary, the offense is complete the moment that electronic solicitation happens. And that focus on the action of using the system for an unlawful purpose is what makes these laws so vital for protecting kids online.
And that profound legal focus brings us to our final thought for you to consider. The statute focuses on procuring or promoting through any electronic means. So how might the constant evolution of virtual learning, of school-sanctioned messaging apps that kind of inherently blur the line between private and professional communication, how might that continue to shape both the opportunities for this specific crime and the critical methods law enforcement uses to detect it?
It raises these fundamental ongoing questions about digital safety, about policy, and about the security boundaries we need to build around education technology in a world that is just, well, perpetually connected.
Something to think about as we move forward. That was The Deep Dive. We'll see you next time.